Hello, everyone, and what's up? More Brian Kohberger, Idaho 4 information coming out. A lot of people had questions. I did make a little post on Twitter giving my initial thoughts, but people wanted to dive in a little bit more. People disagreed with me, which happens. And they just had a lot of questions about what the two new details that have come out, what they mean. And we're going to talk about both of them today, starting with the two new attorneys that are going to be added to the prosecution team. And then we will get to that motion to quash, that subpoena, Bethany Funke, what's going to happen there. So if you guys haven't already, hit that like button on your way in as we begin the video. Subscribe to our channel if you haven't already. We're only like 50 subscribers away. Last time I checked, I can check again right now, to 221,000. We just keep slowly climbing our way. Yeah, we're 50 subscribers away. So if you have not subscribed yet, you could be the 221,000 subscriber to our channel. Thank you so much for joining us today, and let's get into it. So first up, we have the petition to approve special prosecutors on this case. Petition for appointment of a special assistant attorney general comes now. The Latah County prosecuting attorney William Thompson, and pursuant to this Idaho rule, petitions the court for the appointment of a special assistant attorney general, and in support of this request states, I am the duly elected Latah County prosecuting attorney. I have the duty to prosecute all felony criminal actions committed in Latah County pursuant to Idaho Code 312604 as the prosecuting attorney. I petition this court to appoint Deputy Attorney General Jeff Nye and Deputy Attorney General Ingrid Beatty as special assistant attorneys general. I'm not sure how you would exactly say that. Attorney generals, I think, is what I would say, but maybe this is the right way. To assist in the prosecution of State v. Kohberger. I know I have some grammar teachers and experts in the chat, so I'm sure you'll let me know. I seek assistance in this case in order to utilize the expertise and additional resources of the Office of the Attorney General. We have seen this before. In the Alec Murdaugh case, the Attorney General was brought in. More there because of potential conflicts and issues, but they have certain resources that just a county prosecutor's office doesn't have. So it's more resources, more manpower and woman power, more experts, more funding. So that's important. A lot of people are saying attorneys general. Doesn't surprise me. They did it right and I was wrong. Paragraph 5. The Attorney General's office has agreed in writing to assist the Latah County Prosecuting Attorney's Office in this matter. Pursuant to the written agreement, the Attorney General's office has agreed to pay the salaries of its personnel who assist in the prosecution. That's huge. That saves the county money and gives them additional help that they need to focus in on this case, which the Public Defender's Office is allocating a lot of resources to defending Brian Kohberger. So they want to make sure that they put the money, time, energy, and resources necessary to handle this case the right way. So, what did the court think about this? This was filed on April 24th of 2023. Do we think the court is going to allow it? Well, not only did they allow it, on April 24th, the same day, we have the judge order appointing special assistant attorneys general. The above matter having come before the court upon petition of the Latah County prosecuting attorney and good cause appearing, it is hereby the same day ordered that Deputy Attorney General Jeff Nye and Deputy Attorney General Ingrid Beatty be appointed as special assistant attorneys general to assist the prosecution of this case. When you petition the court and you have good cause, it's very unlikely that a judge is going to say no. So, who here thinks, and this is just a poll for you guys. I should have done a poll. Maybe we can. Is it hard? All right, let's do a poll. John's sitting over there today. We're going to do a poll today, and the poll is going to be, what does adding 2 assistant attorneys general to the case show you about how the Latah County prosecutor feels about this case. Something close to that. Okay. And the potential answers are confident, scared, or neither. Neither is just whatever. They needed more. It doesn't matter. They added these prosecutors. It's a nothing burger. Scared means they didn't think they could handle it on their own, so they had to bring in the big guns. Or confident. They feel like they've got a case that they're going to win, and they want to make sure it's done right. Okay, overworked. Overworked is probably a good one. Have you already done it or no? Put overworked in there as well. So 4 options. Can we do 4? All right. Confident, scared, overworked, or nothing. Nothing burger. Why not? Let's do nothing burger. I feel like that's going to get a lot of votes just because it's our thing here. All right. So once that poll is up and we have some votes on it, I will let you know what the results are. To me, I think overworked is probably a good explanation. I think there's probably a good explanation for scared. And I think there's probably a good argument for confident, that they feel like they're going to win and they just want to make sure. Now, fear does not mean they think they're bad lawyers or anything like that. When I say scared, I think fear comes into a prosecutor's mind of letting a murderer go free. Nobody wants to do that. Messing up a very big, high profile, important case. You saw what it did to the careers of the prosecutor in the O.J. Simpson case. Cautious is a good one. Unfortunately, we can't do 20 options, but go vote for whatever one you think is the closest. And if none of those ones work for you, then you can put a nothing burger. But I am interested in what everybody thinks and what their reaction is when they find out that they had to go out and they brought in 2 additional attorneys general. Interesting. I'll probably never forget that. So John, let me know when we have maybe 500-ish votes and we can start to get a feel. Okay, what is it at? Yeah, what is the percentage?
We got 23% confident, 25% scared, 17% neither, and 35% overworked.
Okay, so it is almost a complete split 4 ways. It was like 23% confident, 25% scared, 17% neither, and 33%, 35% overworked. So overworked is winning the day right now, but we will see. We will see how it ends up. All right. Yeah, it's still live, so go ahead and vote if you haven't yet. All right, let's bring up Brian Etten's tweet, which a lot of you tagged me in here. And let's talk about this. So this was filed after we discussed the subpoena, the motion to quash, what was going to happen, why they want to do that. Actually, before I share this, let's talk for a second. So the goal was for the defense to be able to question Bethany Funke, a potential victim or witness in this case that was there, a surviving roommate, about what happened. They believe she has exculpatory evidence. They want to put her up in front of the judge at the preliminary hearing, okay? That was kind of the deal of what we were told. And her lawyers did not want to have to make her come out and testify, didn't want to have her talk to the defense. It doesn't even say that she has exculpatory evidence. It says may. They didn't do the subpoena right. All those objections to try to block it, okay? Then we get here. A stipulation and request for an order. And I will just tell you, if this was attorneys playing nice and everybody was cool and knew each other and trusted each other, they would just say, all right, I'll withdraw the subpoena. Can we just set up an interview? Funke's attorneys say, yeah, let's set up an interview. We'll come out. We'll talk to her. We'll do it by Zoom, whatever it is. We'll make it easier on her, as easy as possible. We know it's a difficult time, but let's do this. That's not what happened. I don't know if these lawyers know each other. I know they're from different states, but it seems like they were only able to get the subpoena withdrawn in a give and take quid pro quo transaction. We will withdraw our subpoena if you agree to an interview. And we will only do all of this if the court orders us to do this agreement. Because if they don't, then we're going to subpoena her because we think we have a right to subpoena her. I do not see this as the defense giving up. I actually see this as a defense win, and we'll talk about why. Who do you think won this situation? Defense, I guess we'll say BF as the other one because the state was not really involved in this as much. All right, comes now Kelly Ann Valoria. That's the lawyer on behalf of Bethany Grace Funk and Evelyn Grosnick, interim Washoe County public defender, on behalf of the defendant, Brian Kohberger, and jointly stipulate that the subpoena issued on April 11, 2023, commanding Bethany Grace Funk to appear before the Second Judicial Court of the state of Idaho, County of Latah, Moscow, Idaho, on June 28, 2023, shall be withdrawn and or quashed. It doesn't really matter. The subpoena power is gone. The threat and the remedies, if she does not comply with the subpoena, are gone. And that Bethany Grace Funk should be released from the subpoena. The basis for this stipulation is that Bethany Grace Funk, through her attorney, has agreed. The basis for this stipulation, the consideration here, for anybody that knows what a contract is, right? Or what an agreement is, an offer, acceptance, and consideration for that. The consideration is she has agreed to an interview with Idaho Defense Counsel in Reno, Nevada. So maybe that's going to be Grosnick that's doing the interview. In lieu, meaning instead of proceeding forward with the subpoena for preliminary hearing now set June 26th through June 30th, 2023. Pursuant to the rule, the undersigned does hereby affirm that the preceding document does not contain the social security number of any person. 26th of April, which was yesterday. Signed by both lawyers. Both lawyers had to agree to this language. Both lawyers had to agree to the stipulation. Both lawyers had to agree to what each side is giving. One side is withdrawing a subpoena or allowing it to be quashed. The other side is agreeing to an interview. And here are some questions. And I love you guys because you bring the questions. So I have some thoughts on what this means, but I'm going to get them out in the form of answering your questions. Christine, welcome to the membership crew. And Brain Go Girl. And MJC with Carrie Lynn. All right. Darcy asked, when is the interview? That's a great question. And the answer is we don't know. But if you want my guess, it will be in advance of the preliminary hearing. They will know what she has to say prior to a preliminary hearing. Does this mean, I'm going to ask myself a question here. Does this mean that, sorry, I just lost my train of thought with the comments. So we don't know when it is, but does this mean that she will not participate in the preliminary hearing? Not necessarily. If she does have actual exculpatory evidence, they may get exactly what they need to file another subpoena. Or if she's cooperating with the defense, because it does not say that she will never be subpoenaed again. Okay. But if she cooperates with the defense, she gives them a statement and it does have exculpatory evidence, they may produce an affidavit. They may produce her by Zoom. They may find other ways to use that exculpatory evidence in the preliminary hearing if one happens. I have heard rumblings and people have told me, thank you, Anita, that people are saying that, well, now they're just going to go to the grand jury and we're never going to have a preliminary hearing. Well, it seems like if you read the rules in Idaho, that's possible. The defendant has a right to a preliminary hearing in the event that the state does not go and get an indictment from the grand jury, which would mean then if they go through the grand jury, then he would no longer have a right to a preliminary hearing. And I will just tell you, her not showing up for the preliminary hearing, whether or not she has what they think is exculpatory evidence, whether they go to a grand jury or a preliminary hearing, these charges are going to stick. We are going to move forward in this case with Brian Kohberger as the defendant. I am very confident in that. Whatever she says in her interview, whatever she would say at the preliminary hearing, I firmly believe it would not be enough for the judge to not find probable cause. I firmly believe that even if the state presents Bethany Funke or whatever it is that she's going to say in a secret grand jury proceeding, they are still going to indict Brian Kohberger for these crimes. So I'm sorry if I'm busting any bubbles or killing any theories, but I firmly would believe that. I would be absolutely floored if a grand jury came back without an indictment, or if they go to the preliminary hearing and the judge is like, nope, not enough to find good cause shown here to go forward on this, regardless of what evidence comes in. I don't think anything's going to happen between now and June 26th to change that. GG Golfer Girl just subbed. Is this going to be a deposition style interview? Great question. Great question. So usually when you agree to an interview, or when someone agrees to an interview with the defense attorney and they are a victim or a witness that we'll just say is more favorable to the prosecution, or seemingly more, maybe not favorable if they're just telling the truth, and maybe that truth can be good for one side or the other, but I should say more friendly with the prosecution, which I'm going to guess she is. Usually it is not a deposition style interview. It's not, you try to make it a little bit less formal. There's not as many rules. Sometimes you'll record it, right? Even if it's not with a stenographer, we'll ask them, can we record this? So that we can play it back, or we can transcribe it. That's something else that happened in the Murdaugh trial. They had some recorded interviews. I think it was with one of the caretakers for the Murdaugh parents, and they had it transcribed. Lawyers do that all the time. I've also seen some rumblings that, oh, this is great because now they can have an interview with Bethany Funke and the state will have no idea what evidence the defense has. And I do not believe that to be the case. While they may not have to just hand over the transcription, if they plan to use anything from it at trial, they will have to disclose it for the most part. But more than that, and even if they don't have to disclose it, because I've seen some rules that I think could be read in some different ways, why in the world would Bethany Funke agree to an interview and talk to the defense and then not also tell the prosecutor what she saw or what she heard or what she specifically told the defense? There's a lot of what ifs. There's a lot of maybes. There's a lot of possibly what could happen. But I see no world in which she tells the defense something that she does not also tell the prosecutor, unless it's something inadvertent where she says, yeah, I woke up that afternoon, and then she tells the prosecutors it was that morning. So the defense is like, oh, she didn't even wake up till afternoon. I'm totally making that up. But an inadvertent difference might happen. But I would be shocked if they found out something from Bethany Funke that the prosecutor didn't already know, or that she's not willing to share with them. So I do not think this is going to be some secret piece of evidence or smoking gun or hide the ball type of deal with the defense. I think this will, whether the rules require it or not, I think this will be disclosed at some point by the defense or by Bethany Funke herself. Jules, anyone have a link to his merchandise store, please? Yes. Can we put it in the chat, John? All right. We will put the merch site in the chat, so you can check that out. It's lawyeryouknow.com. Simple. Ellen, not Sarah Lee. Peter, check your Twitter. Our beloved squirrel passed and help is needed for her funeral. Okay. I did not hear that. That's really sad. Yeah. Feel free to share that in the chat as well, Ellen. And thank you for letting me know. I did not know her personally. I did see her in some chats and on Twitter and things like that. Okay. There is the merch store link. All right. So, other questions surrounding this interview. What will the rules be? How long will it go? And I will tell you, when an agreement is made to interview somebody, the parameters of that are usually very reasonable. An hour, 2 hours, whatever it is agreed upon. Whether or not the attorneys for the victim are going to ask any questions. Sometimes they will, sometimes they're not, or they won't. But usually that's agreed to ahead of time. And honestly, when we have interviews like this, sometimes they're the best kind of interviews because the witness is less nervous. Who will be at the interview? That's a good question. It sounds like lawyers from Reno Nevada representing Brian Kohberger, but if I was his attorney as public defender in Idaho, I'd want to be on that call or in that interview as well. If she's not there, I would absolutely, I would have to absolutely believe that it was going to be recorded. So I do think this interview will be recorded, even though it's not going to be a deposition necessarily, and it's probably not going to be under oath. So what's interesting about that is in different jurisdictions, if you take a statement under oath like a deposition, it can be used certain ways at trial. Some jurisdictions allow you to just enter it into evidence as witness testimony. Others allow you to use it to take certain portions of it. And most jurisdictions, of course, allow you to use it as impeachment. However, prior inconsistent statements, even if they're not under oath, can still be used to impeach a witness. So if she says something in this interview and it's recorded or written down, and then she says something different at the preliminary hearing or at trial, she can, and I believe will or would, be impeached with this prior inconsistent statement, if it exists, as the interview at trial by the defense attorneys. So I guess we put the wrong merch link up, but now it's been corrected. It's lawyeryouknow.com. Susan, this is a great question. Peter, is it possible to get a scheduled time for the live chat video? Because I've missed so many. It used to be 8:45. I miss everyone. Susan, I miss everyone too. I miss the 8:45 chats. 8:45 is so much harder on me because of my family and my kids and being at home. And it just kind of like extends the workday all the way until right before I try to go to sleep. So that's a lot more difficult. So we kind of reserve that for when we're breaking down and reacting to and recapping a trial every night, which some are coming up that we're going to do that to, including the Kohberger preliminary hearing, if that's live streamed in June. Sarah Boone, we've got a couple, in the pipe that are still going to be, we're going to be getting back to that. But I try to do it afternoon, sometime between 2 o'clock and 4 o'clock p.m. Eastern. It changes all the time because, as most of you know, I'm still full-time, full caseload practicing civil trial lawyer. So I usually will block 1 hour as if it's an appointment with a client when I have an afternoon, 3 or 4 days a week to try to get a live video in as often as I can. So I appreciate you. I appreciate you being able to be here. I do miss everybody from the 8:45 live streams and chats as well. We will get back to that in the next trial, but that's kind of where we're at for now. And I try to do it in this kind of similar time block, but it's not always the same time. And I do apologize for that. Azam, Peter, let John say hit the like button on your way out on screen before you end the stream, please. We'll see if we can do that. Ellen, not Sarah Lee. YouTube won't let me copy and paste it. It's in your Twitter DMs. Okay, I will take a look after the video. Beverly, welcome. Netwoman, can Bethany's attorneys limit the scope of questions to only events of that night and not victim shaming like questions of the decedent's sex life, drug use, etc.? So here's the great part about an agreement to an interview. It's kind of like a pre-suit portion of the case when you're not in litigation yet. A judge is not overseeing everything you do, right? You can do pretty much anything. Of course, that's legal and, moral and ethical, but you can agree to basically anything as two attorneys and two sides. They can say we're going to do the interview over 4 days at 30 minutes at a time. We can say we're going to do a 5-hour block. We can say we're only going to do 30 minutes. We can say I'm not even going to ask any questions. She's just going to tell me what happened that night. Or we can say I'm going to ask leading questions. You can agree to pretty much anything in an interview because deposition rules don't necessarily apply. The rules at trial, the rules of evidence don't apply when you're just interviewing somebody that is agreeing to speak to you. Now, if you don't follow certain rules, it can be objectionable later and can potentially be inadmissible later, but they can absolutely limit the scope or they can expand the scope. Whatever the two sides agree to is what can happen at this interview. What type of deposition will it be? Video or video conferencing with the judge? The judge will not be participating. And when you look at what kind of a deposition it's going to be, it's not going to be a deposition for all intents and purposes that we know right now. And it could either be in person, it could be over the phone, it could be video conference by Zoom. It really just depends on what they agree to. What is the purpose of the Nevada interview with the victim and survivor? The purpose is to find out, what does she know? What did she see? What did she do? What happened in the gap between the crimes happening and them calling 911? What did she hear? Were people coming in and out all the time? Was everybody intoxicated that night? Those questions very much could matter. And when you do a deposition or do an interview like this, the scope of relevance is so much bigger than what happens at trial. The rule for something to be admissible in a deposition is it reasonably likely to lead to discoverable material? Meaning the actual question doesn't even have to be discoverable material. It just has to be reasonably likely to lead to something that could be discoverable. So it's a much, much broader net. Will, do you think Brian will ever confess, even if they stack up way more evidence in the next hearing? As it sits right now, I mean, the answer seems like no, but I mean, if you followed the Aiden Fucci trial, he didn't confess till the very end when he was about to go to trial. That type of stuff happens all the time. So it's not really, I don't really know. Leo the Lioness, what's the issue? Why can't she talk? I have no idea. But a lot of victims or potential witnesses refuse to talk to the defense, and that's their obligation. But it's the defense's, I said obligation. That's their prerogative. They can make that decision. But it's also the defense's prerogative too. If they want to force a witness to show up and testify, they can subpoena you. So my guess is she refused to talk to the defense, so they subpoenaed her. So then she agreed to talk to the defense, which is not all that uncommon. All right. So we've answered a lot of questions about this stuff. It's going to continue to trickle out. Feel free to send it to me, Instagram and Twitter at Tragos Law. Give us a follow on there if you guys haven't already. And make sure you subscribe to our channel. And maybe we'll have somebody else tell you to hit the like button on the way out if you stick around through the entirety of the outro for a little encore. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.
What's up, everybody? Just reminding you to hit the like button on your way out. Great to meet y'all.